Good evening and welcome to our webinar on the tax consequences and filing requirements when expatriating. This is the 2017 update. Before we get started, a brief disclaimer. This presentation was prepared for education purposes only. This presentation is not legal or tax advice, nor is it to be construed as such. Each individual circumstances are different. You should seek legal and/or tax advice to address any specific questions you may have. You'll notice in your GoToWebinar console that you do have the ability to type in questions. Please feel free to do so. I will conduct a short question and answer period at the end of this webinar. As this webinar is not specific tax or legal advice, please keep your questions general. If your questions are obviously very specific to your own situation, they will not be answered. Also, this presentation is available for download from your console. You'll have it in PDF version. So anyways, let's get started. I'm your presenter. My name is Jimmy Sexton. Just a brief background on myself. I have a bachelor's in business administration with an emphasis in finance at JD and LL.M in international taxation. I'm the president of Esquire Group. It's an international tax advisory firm with offices in Austria, Germany, the United Arab Emirates, and the United States. We specialize in international taxation, including tax issues facing U.S. citizens and resident aliens living abroad, expatriation, investing or doing business abroad, and/or foreign investment in the U.S. Fluent in both English and German. If you want to know a little bit more about me, you can visit our website. On the profiles page, you'll find my full bio. So, what we're going to cover, what is expatriation? We'll talk about exactly what expatriation is. We'll talk about how you expatriate. We'll give you some facts on expatriation. We'll give you some the tax consequences of expatriation. Talk a little bit about the tax compliance when expatriating, and also about some tax planning opportunities that are available when expatriating. So first off, what is expatriation? So for U.S. citizens, this would be relinquishing your United States citizenship. So basically giving up your U.S. nationality. For U.S. permanent residents, so those with green cards, they can also be considered to have expatriated if they're what's considered a long-term resident and they cease to be a long-term resident. A long-term resident is a lawful permanent resident, so a green card holder of the U.S. and has been for at least 8 of the last 15 years, ending with the date of termination. With the year of termination. So that would be if somebody ceased to be a U.S. permanent resident in 2017, it would be the 15 years ending in 2017. So for U.S. citizens, how do you expatriate? And the answer to that question is by performing an expatriating act voluntarily with the intent of relinquishing U.S. nationality. So that means you have to perform one of these expatriating acts. You have to do so voluntarily, and you have to have the intent that you're going to relinquish your U.S. nationality by performing this expatriating act. So what I'm going to do is I'm going to jump forward to the next slide. We're going to go through what these expatriating acts are, and then we'll come back to this slide and talk a little bit more about how to expatriate. So the main expatriating acts are as follows. Obtaining naturalization in a foreign state upon one's own application after age of 18. So basically, if you acquire another citizenship after the age of 18, that would be considered an expatriating act. If you take an oath, affirmation, or other formal declaration of allegiance to a foreign state or its political subdivisions after the age of 18. That would also be considered an expatriating act. Entering or serving in the armed forces of a foreign state engaged in hostilities against the U.S. or serving as an officer. So that's somewhat limited and leaves a little bit of wiggle room. So one could, for example, serve in a foreign military as long as they weren't an officer and that country was not engaged in hostilities against the U.S., and that would not be considered an expatriating act. Another expatriating act would be accepting employment with a foreign government after the age of 18 if having the nationality of that foreign state or if an oath or declaration of allegiance is required in order to accept that position. Formally renouncing U.S. nationality before a U.S. diplomatic or consular officer outside of the United States. This is probably the most common expatriating act. This is basically when you walk into an embassy, a U.S. embassy outside of the United States, and say that you want to expatriate, and you go through the process of formally renouncing a U.S. nationality before a U.S. diplomatic or consular officer. Another expatriating act would be formally renouncing U.S. nationality within the U.S. This very rarely happens, and this would only be possible in limited circumstances. For example, if the U.S. were in a state of war. And finally, being convicted of an act of treason against the U.S. or for attempting to overthrow the U.S. government, those would also be expatriating acts. So now we're going to go back to the previous slide and examine this a little bit more in depth. So, as we stated previously, the way you expatriate is by performing an expatriating act voluntarily and with the intent of relinquishing U.S. nationality. So if you don't have the intent of relinquishing U.S. nationality, it wouldn't necessarily be considered a relinquishment. So the intent to relinquish is not automatically established when you're naturalized in a foreign country, if you take a routine oath of allegiance to a foreign state, if you served in the armed forces of a foreign state not engaged in hostilities against the U.S., or accept a non-policy level employment with a foreign government. Now, the most common of these is being naturalized in a foreign country. So if you are naturalized in a foreign country, because the intent to relinquish is not automatic, you would have to take another step in order to have that be an effective relinquishment of U.S. Citizenship. So, for example, let's say you were received another citizenship. If you received that second citizenship with the intent to relinquish your U.S. citizenship, you would need to notify a U.S. consular officer that the act was performed voluntarily with the intent to relinquish U.S. nationality. So, for example, let's say you're a U.S. citizen, you later acquire Maltese citizenship, for example. Simply by obtaining that Maltese nationality, that would not automatically expatriate you, because the intent to relinquish is not automatic when being naturalized in a foreign country. So you would have to perform that expatriating act, so being nationalized in Malta, and then you would have to affirm in writing to a U.S. consular officer that when you were naturalized in Malta, that you did so with the intent of relinquishing your U.S. citizenship. And only then would it be an effective expatriation. Going back to that same example, if you perform the expatriating act not intending to relinquish, then you don't have to do anything to not expatriate, basically. So going back to the example of being naturalized in Malta, if you didn't affirm to a U.S. consular officer that you perform that voluntarily with the intent of relinquishing U.S. nationality, then you basically don't have to do anything, and you're not considered to have expatriated, because it's assumed that you did not have the intent to relinquish when you were naturalized in Malta. Some things that can help show that you perform the expatriating act without the intent to relinquish your U.S. citizenship would be, for example, if you, after having received your Maltese nationality, if you then used your U.S. passport again, or voted in the U.S., or did something of that nature, then that would be proof to the U.S. that although you performed this expatriating act, that you did so without the intent of relinquishing your U.S. nationality. So here's a couple of facts for U.S. citizens that expatriate. So you lose the rights and privileges associated with U.S. nationality. One of the biggest things here, which is a question that we get asked a lot, is, well, if I expatriate, can I go back to the United States? I would say generally the answer is yes. But if you've expatriated and given up your U.S. nationality, you don't have a right to return to the United States. You're basically like any other foreigner, and going to the U.S. is a privilege. And there's a very common misconception that people who are citizens of countries that are on the visa waiver program, that's most European countries, that they can travel visa-free to the United States, and that they somehow have a right to enter the United States due to this visa waiver program. That's not the case. Certainly if you expatriate and your remaining nationality is from a country that is on the visa waiver program with the United States, it makes it much, much easier to enter the United States, but you don't have a right to enter the United States. So that's one very important thing to keep in mind, is that it is possible that by expatriating that you wouldn't be allowed to return to the United States. Secondly, expatriation is irrevocable. So the next day, there's no cooling off period where the next day you can say, oops, I didn't want to do that. I'd like to have my passport back. It's not impossible to get U.S. citizenship again, but you would have to get it through, basically the same way any other foreigner would get it. Marry an American, or if you were able to get a green card and later turn that into citizenship, something of that nature. A parent and or guardian cannot relinquish U.S. citizenship for a child or an incompetent person. Expatriation is personal to each individual, so nobody can do it on your behalf. So most embassies, the embassies are allowed to determine the age for somebody to expatriate. Generally, I would say that's 14 for most of the embassies. If you're only a United States citizen and you have no other nationality and you expatriate, you would become stateless. Basically, you'd be a citizen of nowhere. The U.S. doesn't really allow its citizens to become stateless, so it's pretty much impossible to expatriate without having another nationality. Expatriating doesn't have any effect on tax or military obligations prior to expatriation. There's a very common misconception, especially amongst Americans abroad that aren't in tax compliance, that by expatriating, they're getting rid of their tax problems, and that's false. The non-compliance happened while you were a citizen, and so you still have a responsibility to clear those tax problems up. Expatriating isn't going to relieve you of those tax issues. You don't have any protection from prosecution from crimes committed in the U.S. So as an expatriate, if you were in the U.S. and committed a crime, you wouldn't have any protection from prosecution. and it does not alleviate financial obligations incurred in the U.S. or by U.S. citizens abroad. And that's somewhat related to not having an effect on your tax or military obligations prior to expatriation. If you had any debts in the U.S., including a tax debt that you incurred while you were in the U.S., or if you're a U.S. citizen living abroad, then you're still going to be responsible for those after expatriation. How do I expatriate for long-term residents? So again, these are green card holders, permanent U.S. permanent residents that have been for 8 of the last 15 years. So the way you expatriate, the most common way to expatriate is by abandoning your permanent resident status by filing Form I-407. Another way of terminate or expatriating as a long-term resident is commencing to be treated as a resident of a foreign country pursuant to a tax treaty with the U.S., and you don't waive the treaty benefits, and you inform the IRS by filing Form 8833 and 8854 that you intend to be treated as a resident of that foreign country and cease to be a U.S. permanent resident. So where this is sometimes very relevant is, for example, the United States has tax treaties with most European countries, and in those tax treaties, it defines who is considered a resident of the contracting countries to that tax treaty. And let's say you were a German citizen with a green card and living in Germany. Because you're a green card holder, even if you're not living in the United States, you're still liable for tax on your worldwide income in the United States because of that green card. But because you're a foreign national and you're resident in a foreign country that has a tax treaty with the United States, you could claim to be a resident of Germany. And if you do that and you didn't waive any treaty benefits that are afforded you in the treaty, and you filed Form 8833, which is a treaty-based return position to inform the IRS that you wanted to be treated as a resident of Germany and basically not be subject to U.S. tax on your worldwide income, and that you were intending to cease your U.S. residency status by filing Form 8854, then that would also be considered expatriation. Finally, you would be considered to have expatriated and abandoned your permanent resident status if your permanent resident status was revoked or administratively or judicially determined to have been abandoned. So basically, they took it away from you. So if you're a long-term, so permanent resident that's considered a long-term resident, and you go ahead and give up your permanent resident status or your green card, basically what you're losing is your right to permanently reside in the United States. That's what the green card essentially afforded you. So what are the tax consequences of expatriation? And this applies equally to U.S. citizens who relinquish their U.S. citizenship and to green card holders, permanent residents who are considered long-term residents that cease to be. So the tax consequences depend on whether or not you're considered to be a covered expatriate. So first, let's take a look at who a covered expatriate is, and then we'll talk about some of the tax consequences if you are a covered expatriate. So first, if you have a net worth of $2 million or more, you are considered a covered expatriate. This $2 million or more net worth is per person. So let's say, for example, you had a married couple and the assets belong jointly to them, 50-50. Each one of them would have a net worth of 2 million. Because it's a net worth of 2 million or more, they would both be considered covered expatriates under the net worth test. But for example, let's say that you had two spouses that had a combined net worth of 3.8 million. If you divide that in two, you come up with 1.9 million apiece, which is under the $2 million net worth threshold. Both of them under the net worth test only would be non-covered expatriates. Another one of the criteria is annual average U.S. income tax liability of more than $162,000 for the 5-year period prior to expatriation. So one of the things that is important to note here is it's not more than $162,000 of income. So more than $162,000 of income tax. So in order to pay $162,000 in income tax, your income would have to be much, much higher. So it's the annual average U.S. income tax liability for the period, for the 5-year period prior to expatriation. So basically what you do is you add up the 5-year, you take the tax liability in each of the 5 years prior to expatriation, you add it all together and you divide it by 5. And if that number is 162,000 or more, then you would be a covered expatriate under the annual average U.S. income tax liability test. Now, what's different with the income liability test than with the net worth test is the net worth test, it's 2 million per person. With the tax liability test, if again you had, let's say, married spouses that were filing a joint income tax return, the 162,000 would not be allocated 50-50 between the spouses. It would basically be if married filing jointly and the income tax liability on their joint tax return was more than 162,000, they would both be covered expatriates pursuant to the tax liability test. And finally, if you fail to certify U.S. tax compliance for the 5-year period prior to expatriation, then you would also be a covered expatriate. And this is one where we see a lot of people get tripped up. If you recall, before I was stating that expatriation will not alleviate you of tax obligations in the United States prior to expatriation. This is a perfect example that if you were not tax compliant for the 5 years prior to expatriation, you're going to be considered a covered expatriate. So, if you have a net worth of under $2 million and you have an annual average income tax liability of less than 162,000, as long as you're tax compliant, you could expatriate as a non-covered expatriate. But if you're not U.S. tax compliant, then you would be a covered expatriate. And again, in the next slide, we're going to talk a little bit about what that means to be a covered expatriate, what goes along with that. And this failure to certify compliance with U.S. tax obligations, this is something where we see people get tripped up a lot. A lot of people truly believe that they are in tax compliance, but then when we go to review their tax returns, we realize that they maybe forgot a couple euros worth of interest in one of the years, or they used a wrong exchange rate on something, and then all of a sudden they're not in tax compliance. And if they would have expatriated without having first fixed those errors, they'd be considered a covered expatriate. Now, there are some exceptions to the net worth test and the tax liability test for being a covered expatriate. So even if your net worth was 2 million or more and your average U.S. tax liability was more than 162,000, you could still be an uncovered expatriate so long as you were U.S. tax compliant for the 5 years prior to expatriation, and you were a dual citizen at birth, and you continue to be a citizen of and be taxed as a resident of that other country and have not been a U.S. resident for more than 10 out of the last 15 years. So to use that as an example, let's say, for example, somebody was born a dual citizen between Austria and the United States. And this person continues to be a citizen of Austria, lives in Austria, is taxed as resident in Austria, and has not been a U.S. resident for more than 10 of the last 15 years. So long as this person was U.S. tax compliant for the 5 years prior to expatriation, they would be exempted from the net worth test and the tax liability test for being considered a covered expatriate. And the last exception is if the person relinquishes their U.S. citizenship before the age of 18 and a half and has not been a U.S. resident for more than 10 years prior to relinquishment, then that would also be an exemption from the net worth test and from the tax liability test, but not from the tax compliance test. So you always have to be tax compliant. There's no exclusion from that. So what does this mean in terms of actual tax consequences being a covered or non-covered expatriate? A non-covered expatriate can generally expatriate without any tax consequences at all. Covered expatriates, on the other hand, do have some tax consequences. The first of which is a mark-to-market tax on unrealized gains. So basically, you're treated as having sold all your assets on the day before expatriation. So let's say, for example, that you own some real estate and a portfolio and a couple other capital assets, and you paid $2 million for these assets, and now they're worth $3.5 million. You're going to be taxed as if you sold those assets for $3.5 million on the day before you expatriated, which is a $1.5 million gain, which would be taxable. Now, the IRS is nice enough to give a $699,000 gain exclusion. This is the 2017 exclusion. It goes up a little bit every year to adjust for inflation. So going back to that same example, you have assets that you paid $2 million for. They're now worth $3.5 million. You expatriate. You have a mark-to-market gain of $1.5 million. That $1.5 million would be reduced by the $699,000 gain exclusion, and the remaining gain would be taxed at applicable capital gains tax rates. Also, covered expatriates that have deferred compensation items like IRAs, 401ks, annuities, pensions, life insurances with a cash value, things of that nature. Those items will be treated as if they were distributed on the day before expatriation, and the income from those items would have to be included on their income tax returns. Additionally, and this actually applies to non-covered and covered expatriates alike, is the gift tax exclusion. So for 2017, Americans have a $5.49 million gift tax exclusion. That means throughout their lifetime, they can give away up to $5.49 million free of gift tax. That is lost once someone expatriates. Again, I have that under the covered expatriate section here, but that applies equally to covered and uncovered expatriates. One of the things to keep in mind there is that after expatriation, for uncovered expatriates, only gifts of U.S. property would be subject to gift tax anyway. So if somebody were a non-covered expatriate and they gave, let's say, money that they had in Germany to somebody in America, there wouldn't be any gift tax anyway because it's not U.S. property. If, on the other hand, this German citizen living in Germany owned a piece of real estate in the United States and wanted to gift that to somebody, because that property is situated in the United States, would be subject to a gift tax. Also, estate tax. The estate tax exclusion for U.S. citizens is for 2017 is $5.49 million. That is reduced to $60,000 after somebody expatriates. And again, the estate tax for a non-covered expatriate would only apply to property in the United States. So for covered expatriates, the rules with gift and estate tax are a little bit different. So again, if you're a non-covered expatriate, even though you lose your lifetime gift and estate tax exclusion, the gift and estate tax would only apply to assets in the United States, so U.S. property. For covered expatriates, it's a little bit different. So for covered expatriates, if they give a gift to a U.S. person, so basically a U.S. citizen or somebody resident in the United States, it is the recipient of that gift, the U.S. person recipient of that gift, that will be liable for gift tax at the highest gift tax rate in effect that year. Also for covered expatriates, the U.S. estate tax applies to any U.S. person that receives an inheritance from a covered expatriate. So basically, any gifts or inheritances from a covered expatriate to a U.S. person, that U.S. person is going to be liable for the gift or estate tax on that. And this applies to gifts or inheritances from the covered expatriate, regardless where in the world this gift or inheritance comes from. That is in stark contrast to the non-covered expatriate, where gifts and estate tax would only apply on property within the United States. For a covered expatriate, gift and estate tax will apply to U.S. property. It will also apply to property gifted or inherited by U.S. persons from anywhere in the world. And it'll be subject to the highest gift or estate tax rate in effect. For 2017, that rate is 40%. One of the really tricky things is the IRS issued some regulations last year that says it is the recipient of the gift or bequest who is responsible for determining if that gift or inheritance came from a covered expatriate. So if you're a U.S. Citizen or a green card holder, or you're living in the U.S., and you receive a gift or inheritance from somebody who you may believe to be a foreigner, you have to determine if that person is a covered expatriate or not, because it's your responsibility to know that. And if you don't have that proof that they are not a covered expatriate, then the IRS could tax that gift or inheritance that you receive. So this is something where we've been working with clients who have expatriated recently to put together a sort of package for potential heirs proving their covered expatriate or non-covered expatriate status, so that any of their recipients of gifts or inheritances will have that information available. This applies to all expatriates. Like I mentioned this briefly on the previous slide, you lose your lifetime gift tax exclusion, you lose your estate tax exclusion, and also depending on your residence, there's possible withholding tax on some types of U.S. source income. So example, if you're receiving interest, dividends, pensions, or Social Security from the United States, there could be a withholding tax of up to 30% on that income. If the country that you're resident in has a tax treaty with the United States, that withholding tax is often reduced below 30%. So what are your tax responsibilities in terms of filing when you expatriate? So in the year of expatriation, you have to file what's known as a dual status tax return. Part of the year as a U.S. resident, part of the year as a non-U.S. resident. You also have to file Form 8854. Failure to file 8854 results in you continuing to be taxed as a U.S. citizen or resident until you file. So even though you formally went and relinquished your U.S. citizenship, for example, if you fail to file this Form 8854, which is your notice to the IRS that you expatriated, you're going to continue to be responsible for tax in the United States as a U.S. citizen or resident until that 8854 gets filed. Also, there's a $10,000 penalty for failure to file the 8854 or not including all the information required or including incorrect information on the 8854. So the 8854 is very important to file and very important to get right. Also, if you continue to receive any income from U.S. sources, you'd have to continue to report those on a U.S. tax return if full withholding was not done by the U.S. payer of that income. Just briefly to tax planning, through proper tax planning and review, a lot of the tax consequences of expatriation, especially for potential covered expatriation, covered expatriates, can be greatly reduced, sometimes eliminated. There's been many instances where with proper planning, we've been able to take an otherwise covered expatriate and make them uncovered. It is also imperative to ensure that you're in full tax compliance for those 5 years prior to expatriation, because this is something that makes someone who would otherwise be an uncovered expatriate a covered expatriate. So that brings us to the end of our presentation. I'm going to take a look here and see what questions, if any, we have, and I will try to do my best to answer them. So, one person asked the question, have you ever had a situation where an individual gifted assets to reduce net worth and therefore became non-covered, expatriated in the same year, and then claimed the unified credit and filed the 709, which is a gift tax return, the following year after expatriation? The answer is yes, that's fairly common. The second question is a little bit more specific, so I'm not going to answer that question as I ask these questions to stay very general. The next question is also very specific, so I'm going to skip that one as well. Again, very specific questions here that are not general in nature. Here's one that says, why wouldn't you always max out the exclusion by giving a gift before expatriation? I think that depends very much on the person's situation. You know, assuming they have enough assets to max out the exclusion, you know, that would presumably mean that the person would otherwise be a covered expatriate. A lot of people don't want to give away all their assets prior to expatriating. They still want to have it. Is probably the main reason that people don't max out the exclusion by gift before expatriation. Uh, some people do, but I think it really depends on the individual circumstances. Another great question is if you've expatriated and have a social security number, if you later have U.S. source income, can you continue to use your social security number that you had prior to expatriation? The answer is yes. You would continue to use your social security number that you had prior to expatriation. Another question was one regarding a Roth IRA. This is a little bit too complex of a question to answer in this Q&A period, but it is a very interesting question. The other question, which is not specifically a question related to expatriation, but it asks if we'll be doing any webinars on using self-directed IRAs to own foreign property or using domestic LLCs to own foreign property. We don't have any webinars on that topic planned, but that's certainly a very good topic, and we'll consider doing one of those in the future. The last question, how many years are counted when it comes to consider a pension distributed? Unfortunately, I don't quite understand that question. Anyway, it seems like those are all of the questions. Thank you for participating in our webinar tonight. I hope that, or this morning, depending on where you're located in the world. I hope that you found it informative and that it's answered some of the questions that you may have had about expatriation. Thank you very much.